We usually think of constitutional rights as these rock-solid things, like a literal shield you can just hold up when you need it.
Right.
But then you actually take that shield out onto the street, say, I don't know, during a traffic stop, or into the back of a police cruiser at 3 in the morning.
Oh, yeah. Totally different environment.
Yeah, and suddenly that solid metal shield feels, well, a lot more like paper. Today, we are putting that shield through a massive stress test.
Exactly. Our mission for this deep dive is to explore how those rights actually hold up in real-world encounters and, in courtrooms.
Right, because it's one thing to read the Bill of Rights in a classroom.
Oh, for sure. It is a completely different thing to see what happens when the legal system is tested right there on the pavement.
So to do that, we're unpacking a stack of sources today. Specifically, we're looking at transcripts from 3 really highly detailed videos from a YouTube channel called The Civil Rights Lawyer.
A great source for this kind of on-the-ground legal analysis. Very detailed. And before we even lay out the narrative, let's establish a clear baseline for you, the listener. We are here to impartially report the facts and the legal analysis exactly as they're presented in this specific source material.
Right. We are not taking sides here.
No, not at all. We aren't endorsing any political viewpoints regarding law enforcement. We're really just looking at the observable events and the legal principles detailed in these specific videos.
And the central figure in our sources today is Officer Michael Bell, who at the time was with the Grayson, Kentucky Police Department. And the sources focus on 2 completely different body cam incidents involving him.
And these are basically polar opposite situations.
Oh, absolutely. One involves a perfectly sober, totally compliant individual, and the other involves a highly intoxicated, very non-compliant college student.
So we are going to see how power, the law, and just, human behavior collide in 2 completely different extremes. Let's start with the first incident.
Okay, let's do it. We begin with what should realistically be the most mundane, forgettable police interaction on the planet. A minor traffic accident.
Right, a literal fender bender.
Yeah. So Nate Stevens, who the sources note is a personal trainer, he lives a very clean lifestyle. He's driving in his own neighborhood. A 17-year-old neighbor accidentally backs out of a driveway and just bumps into his truck.
Just a bump. And they exchange information. The scene is totally calm. But a parent calls the police just to get a standard report on file for insurance purposes.
Which is pretty standard.
Very standard. So Officer Bell and his supervisor, Sergeant Hall, arrive on the scene.
And almost immediately, this interaction just totally shifts.
Yeah.
Officer Bell starts claiming that Nate is acting erratic, that he's stumbling around, and that he smells of alcohol.
But remember, the body cam is rolling this entire time.
Right. And the video shows Nate standing perfectly still, speaking incredibly calmly.
Yeah, the objective reality captured by the camera simply does not match the subjective narrative the officer is voicing.
It's wild. Because Nate knows he's completely sober. He actually even leans over and blows his breath toward Officer Bell just to prove he doesn't smell like alcohol.
And Bell takes this as an aggressive move.
Yeah, he threatens to arrest him for menacing right there. But Nate, keeping his cool, he agrees to take a portable breath test. And he blows a 0. Literally 0.000.
Yeah, nothing.
To my mind, that should just be the absolute end of a DUI investigation.
It absolutely should be, because the suspicion of alcohol has been definitively removed at that point. But Bell then asks Nate to perform field sobriety tests.
Which is just, wow.
Right.
Okay. And Nate complies.
He does. He does the walk and turn test, executing it perfectly. Then they move to the one-leg stand.
A flamingo stand.
Right. And the source describes how Nate balances flawlessly, counting all the way to 30 while just staring Bell right in the face.
So Nate finishes, and Officer Bell tells him, basically, if you hadn't taken these tests, I had enough to arrest you for a DUI. But since you took them and passed, you're not going to jail.
And this right here is the hinge upon which the entire encounter turns.
Because Nate replies, simply, you would have got sued.
Yep. And Officer Bell immediately retorts, that's qualified immunity. I wouldn't have got sued.
Okay, let's unpack this for a second, because that term gets thrown around a lot in the news, but I really think a lot of people don't fully grasp how it works on the street. What exactly is qualified immunity in this context?
So qualified immunity is a legal doctrine established by the Supreme Court. It essentially shields government officials, including police officers, from being held personally liable for constitutional violations.
Like a false arrest.
Exactly. Unless the official violated a clearly established statutory or constitutional right.
What does clearly established mean practically?
In practice, it means that unless a court has previously ruled on a nearly identical set of facts, the officer is immune from a civil lawsuit.
Wow.
Yeah. So Bell is essentially telling Nate that the legal bar to successfully sue an officer is incredibly high, so the threat just doesn't worry him.
It's basically a legal force field, and Bell is clearly very confident in it. Because right after that exchange, Bell actually takes his body cam off his chest, covers the microphone, whispers something privately with his supervisor.
Which is always a red flag.
Totally. Then he puts the camera back on and tells Nate, the guy who literally just blew a zero and did a perfect balance test, that he is now under arrest for a DUI.
Incredible.
He puts him in the cruiser and orders Nate's truck towed to the impound lot, despite it being parked completely legally on Nate's own street.
And the sources argue this is a profound escalation, because if we look at the mechanics of constitutional law, we have to talk about probable cause.
Right.
Under the Fourth Amendment, a warrantless arrest requires objective facts that would lead a reasonable officer to believe a crime has been committed.
But the objective facts here literally proved his innocence.
Exactly. Bell lacked any objective evidence of impairment. The video analysis points out that this appears to be a strictly retaliatory arrest, driven by the officer's reaction to the threat of a lawsuit.
So it wasn't about enforcing the law.
No, it was an arrest made to enforce submission.
Yeah. And getting wrongfully arrested on the street, that's really only the first part of the process. The second part is seeing how the justice system actually processes that arrest when the official written police report directly contradicts the video evidence.
Yes.
Because historically, an officer's sworn written report is given immense weight by the court.
Huge weight. And that brings us to Nate's lawyer, Derek Willis, who obviously obtains the body cam footage. And he uses a specific legal venue called a refusal hearing to cross-examine Officer Bell.
Okay, wait, how does a refusal hearing actually work? Because it's not the actual criminal trial.
Right, not at all. It's an administrative hearing. So when you get a driver's license, you operate under implied consent laws.
Meaning you agree to take a breathalyzer.
Right. You agree to submit to chemical testing if you're suspected of a DUI. If you refuse, your license is automatically suspended. So a refusal hearing is just to determine if that suspension holds.
Oh, you got it.
But smart defense attorneys use these hearings strategically. They are really low stakes for the prosecution, so officers often come in super unprepared.
Oh, I see where this is going.
Yeah. The defense lawyer can get the officer under oath, lock them into their written narrative, and then introduce the contradictory body cam footage before the criminal trial even begins.
It's a trap.
Exactly.
And that is exactly what Willis does. According to the transcript, Bell's written report claimed Nate failed the eye test, that he stepped off the line during the walk, and that he used his arms to balance during the one-leg stand.
Just total fabrications.
Yeah, because under oath, Willis corners Bell with the footage. The video clearly showed Nate's arms perfectly still at his sides. Willis completely forces the officer to admit that Nate blew a zero, that he was fully cooperative, and critically, that a citizen's nervousness does not legally equate to impairment.
Which completely dismantled the foundation of the probable cause. But, a highly significant legal moment in that courtroom was regarding Nate's right to counsel.
Oh, right, at the hospital.
Yeah. So before they tried to draw Nate's blood, Nate explicitly wanted to call his lawyer, and Bell refused to let him.
And his excuse was insane.
Bell claimed that if the lawyer showed up, he'd be considered a witness to the investigation and therefore couldn't represent Nate.
Which just sounds completely made up on the spot.
Oh, it is an absolute fabrication of legal procedure. While implied consent does require you to test, you are legally afforded the right to contact an attorney before submitting to that chemical test in many jurisdictions, including Kentucky.
As long as it doesn't hold things up too much.
Right, as long as it doesn't unreasonably delay the process. By denying Nate that right through outright deception, Bell violated the legal protocols of the test itself.
So the judge sees all this, rules in Nate's favor, and sets aside the blood test refusal entirely.
A huge win.
Yeah, and eventually the prosecutor just drops the DUI entirely. Nate takes a 90-day deferred adjudication for a totally minor traffic charge, I think it was, not having his physical license on him, just to clear his name and move on.
Yeah, and for those unfamiliar, deferred adjudication just means you accept responsibility for a minor charge and the court delays the conviction. If you stay out of trouble for the set period, like 90 days here, the charge is dismissed.
It's just a pragmatic way to end a legal nightmare.
Exactly.
But, I can totally hear people listening to this and playing devil's advocate. They might say, look, if Nate had just kept his mouth shut about suing the guy, he would have gone home and slept in his own bed.
People always say that.
Right. But isn't the whole point of a free society that you shouldn't have to stay quiet to avoid a false arrest?
Absolutely. And the sources actually address this directly by citing a specific ruling from the Sixth Circuit Court of Appeals, which is the federal jurisdiction covering Kentucky.
What do they say?
That court explicitly held that the freedom of individuals to verbally oppose or challenge police action without risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state.
So even insults are protected, right? Because I know there are cases where people have sworn at officers and the courts protected them.
Oh, yeah. The Sixth Circuit has held that even directing profanity at a police officer during a stop is protected speech under the First Amendment.
Wow.
Retaliating against protected speech with an arrest violates both the First Amendment right to free expression and the Fourth Amendment right against unreasonable seizure. Your rights do not just evaporate because you annoy an authority figure.
Well, Nate's case definitely shows us how Officer Bell handles a challenge from a sober citizen who knows his rights. But the legal standard of reasonableness is really stress-tested when the citizen isn't calm, isn't compliant, and is actually breaking the law.
Right, a much messier situation.
Which happened exactly a month later. And that brings us to the case of Khalil Ware.
Just 1 month after Nate's arrest, Bell encounters 19-year-old Khalil Ware. Now, Ware is a college baseball player. It's 3 in the morning in a Taco Bell parking lot. Naturally, Ware is dangerously drunk. He's asleep in the back of a designated driver's car. He had been throwing up, and the driver just couldn't get him out of the vehicle.
But the sources note a crucial detail here. Ware is not aggressive. He is non-compliant, he's stumbling, he's slurring, but he isn't throwing punches.
Right, he's not fighting them.
He is just a highly intoxicated teenager who won't or physically can't follow instructions to sit up straight.
Yeah.
So Bell and another officer, Cole Cordell, respond. And the escalation is incredibly rapid. They basically shove Ware into the back of the cruiser and handcuff him.
And because Ware keeps trying to stand up in the back seat, Bell pulls his taser and uses it in drive stun mode, literally pressing it directly against Ware's leg, simply to get him to sit down.
A taser on a handcuffed guy in the back of a car.
Yes. Drive stun is a pain compliance technique. Applying it to a handcuffed suspect who is already fully enclosed in a vehicle raises immediate serious questions about the proportional use of force.
And it gets worse. They transport him to the police station and put this heavily intoxicated, handcuffed teenager into a locked observation room.
Alone.
Yeah. Where he keeps standing up, he's bouncing off the walls, clearly having no idea where he is. Bell opens the door, holding a can of pepper spray, and threatens to spray him if he doesn't sit down.
And we need to understand the physical reality of pepper spray in a confined, unventilated space. It is severe. It doesn't just affect the target. It aerosolizes, contaminating the entire room.
So the sources describe the body cam footage of what happens next. Bell opens the door. Ware is just standing in the corner, motionless, literally saying please.
Just standing there.
Yeah. Without issuing any prior command, without saying a single word, Bell sprays the pepper spray straight into the handcuffed teenager's face.
Unbelievable.
And Bell actually has to walk outside multiple times to cough and catch his breath because the overspray is hitting him out in the hallway. Yet they leave Ware, hands cuffed behind his back, sealed in that contaminated room for over an hour.
You can actually hear him on the video crying, "I can't breathe."
It's awful. Later on, they open the door, Ware is screaming again, and Bell sprays him in the face a second time, still handcuffed.
And there is no medical attention provided until a supervisor, Sergeant Smith, arrives an hour later.
Thank goodness he showed up.
Yeah, Smith immediately de-escalates the situation. He talks to the kid calmly, walks him to a sink, and washes the chemical agent out of his eyes. Just basic humanity.
Ware ultimately pleads guilty to public intoxication and pays a fine. But let's look at the mechanics of the force used here. The source material analyzes this through something called the Graham factors.
Right, which comes from a landmark 1989 Supreme Court case, Graham v. Connor.
Okay, break that down for us.
That case is the absolute bedrock of how courts determine if a police officer's use of force was objectively reasonable. Before Graham, lower courts really struggled with how to judge excessive force. The Supreme Court established that you can't use 20/20 hindsight. You have to judge it from the perspective of a reasonable officer on the scene.
I always like to think of the Graham factors like a sliding scale or a thermostat. The hotter the threat level of the suspect, the more heat or force the officer is legally allowed to apply to gain control.
That is a really highly accurate way to frame it. The courts basically look at three main factors to determine the temperature of that threat. First, the severity of a crime at issue.
Okay, so if we apply that to where he was cited for public intoxication, that's essentially a low-level misdemeanor.
Right.
So the thermostat should be very low. And the sources point out that the Sixth Circuit has explicitly stated that disorderly conduct and public intoxication are not serious crimes that justify severe force.
Exactly. So then the second factor is whether the suspect posed an immediate safety threat to the officers or others.
Again, applying this to where he was in a locked observation room, handcuffed behind his back, he posed absolutely zero physical threat to the officers standing safely outside the room. The thermostat stays low.
And the third factor is whether the suspect is actively resisting arrest or attempting to evade arrest by flight.
Well, he's locked in a room.
Right. He is handcuffed in a locked room inside a police station. He is not fleeing anywhere. The Sixth Circuit has been incredibly clear on this exact scenario. No reasonable officer would continue to spray a chemical agent into the face of a handcuffed, hobbled, or subdued arrestee who is not actively resisting.
So by all three metrics of the sliding scale, the force was legally unjustified. I mean, using a taser and pepper spray on a handcuffed, stumbling drunk teen just to get him to sit down, that is like using a sledgehammer to swat a fly. It's not just excessive, it's punitive.
It's punishment without trial.
Which brings us to the ultimate question of this deep dive. Accountability.
The big one.
Yeah, we have seen a retaliatory arrest of a sober man and a punitive use of force against a highly vulnerable teen, both perpetrated by the exact same officer within a month of each other. So how does the system correct itself?
Well, the public response is often the first layer. The mayor of Grayson actually released a statement regarding these incidents.
What did he say?
He defended the officers to a degree, stating that officers do dangerous, fast-paced work and must make split-second decisions. He also pointedly noted that Khalil Ware was convicted of a crime.
The split-second argument is so common. But the legal analysis in the sources totally counters that. Leaving a teenager in a contaminated room for an hour isn't a split-second decision.
No.
It is a sustained, hour-long choice.
Exactly. But before these cases could fully work their way through the internal review processes, Officer Bell actually resigned from the Grayson Police Department.
And a resignation usually halts internal affairs investigations, right?
Right, because the officer is no longer an employee, meaning the investigation is usually closed without a formal finding of misconduct.
So Bell resigns, but he doesn't leave law enforcement.
No.
According to the sources, he was quickly hired by the Paintsville, Kentucky Police Department, which is just a town over. And only a month into his new job, Paintsville officers are involved in a critical incident.
A major one.
Following a motorcycle pursuit, officers use a taser, pepper spray, and then open fire, shooting a man.
Now, the official public report released about the shooting names 2 officers, neither of which is Bell.
Now, but the sources from the civil rights lawyer, citing inside law enforcement contacts, explicitly place Bell at the scene of that shooting. And while we don't know his exact role in that incident, the pattern is just notable. I have to ask, if an officer can simply resign before an internal investigation finishes and just move to the next town over and put on a new badge, what does that mean for the actual concept of accountability?
It highlights a massive systemic vulnerability known as the wandering officer phenomenon. To really understand why this happens, you have to look at the structure of policing in the United States.
Okay.
It is incredibly decentralized. There are roughly 18,000 independent local, state, and federal law enforcement agencies.
18,000. So there isn't just one big HR department for all police.
No, not at all. There is no mandatory comprehensive national database that tracks police misconduct or the specific circumstances of an officer's resignation. While the National Decertification Index exists, its use is very uneven, and an officer who resigns before being officially decertified often won't even show up on it.
So they just slip through the cracks.
Yes. Jurisdictional red tape, state laws regarding personnel records, and specific union contracts often completely prevent departments from sharing disciplinary histories. An officer facing discipline in one town can just resign in lieu of termination, keeping their state certification entirely intact.
And then what?
They simply apply to a neighboring department that might be desperate for trained manpower and willing to look the other way, or the new department might be entirely unaware of the officer's history. It leaves communities so vulnerable to repeat actors.
You think the system filters out the bad actors, but often they're just relocated to a different jurisdiction.
Exactly.
Let's bring this deep dive in for a landing. We've covered a lot of ground today, but there are a few core takeaways you really need to keep in your back pocket. First, the absolute vital importance of body-worn cameras for transparency. In both of these cases, the official written police reports were demonstrably inaccurate when compared to the video. The cameras provided the objective truth.
They're essential. And the second takeaway is the necessity of understanding the mechanics of your rights, specifically the First and Fourth Amendments. Nate Stevens avoided a permanent DUI conviction because he knew he had a right to an attorney before a chemical test and a right to verbalize his dissent without facing a legally sound arrest.
Right.
Your rights only exist if you and the legal advocates you hire understand how to defend them in these administrative and criminal hearings.
And the third takeaway is recognizing the systemic hurdles that still exist. The Graham factors give us a sliding scale to measure force on paper, but the decentralized nature of the wandering officer loophole means accountability is incredibly difficult to track across city lines.
The system relies entirely on public vigilance and independent verification.
We started this deep dive talking about a shield, how constitutional rights are supposed to protect you. I want to leave you with a final thought to mull over. Think about those body cameras. Think about the exact moment Nate blew a zero, or Khalil was standing handcuffed and motionless in a corner before the pepper spray was deployed.
Right.
If those cameras hadn't been rolling, or if the technology didn't exist, the official written police reports would have become the unquestioned historical record. As you look back over the last century of the justice system, how many perfectly legal, binding convictions were built entirely on creative writing rather than facts, simply because the technology to dispute them didn't exist yet?